SJC-13158, Commonwealth versus Joseph William Beatty.
Okay, Attorney Reardon, whenever you're ready.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Joseph Beatty. The first issue presented is the defendant's competency to stand trial, and more particularly, the judge's failure to consider trial counsel's representations about how his relationship was functioning with the defendant. Now, there's no dispute that there was a substantial amount of psychological evidence concerning the defendant's competency. But the competency is a legal question, not a medical question. And the standard under the Draper versus Missouri case is the defendant is not competent if he lacks capacity to understand A, the nature and object of the proceedings against him, B, he's unable to consult with counsel, or C, he is unable to assist in preparing his defense. Throughout the trial, defense counsel was telling the judge about how he was unable to work with the defendant. On the first day of trial, he told the judge that the defendant did not understand the difference between a jury trial and a bench trial and a plea. This case was a serious case that had been going on for 10 years. It was a very large amount of discovery, but the defendant thought that it was going to be a one-day trial. He told the judge that the defendant was not processing and absorbing the strategic considerations.
You know, counsel, can I have a question about
Yes.
the competency? That's something that's usually evaluated on a very current basis, isn't it? So shouldn't we be looking at the last event regarding competency rather than, because he had been found competent, not, I mean, moving in and out. So what was the last evaluation on competency?
Well, he was evaluated during the trial.
So what did they conclude then?
Well, again, there was, all of the clinicians did find him competent.
So what do we do, Mr. Reardon, with the clinicians who appropriately look at whether he can communicate, his capacity to communicate with counsel, and they say A, and then counsel says, well, wait a minute, this is what's happening to me on the ground, and the judge has this conflicting information. Isn't that the judge's call, or how do we assess what happened with the counsel versus what the clinicians say? Yes,
well, and so that's the nub of the case. And I refer you to the Crowley case, where in that case, the court considered the defense counsel's representations about how his relationship was functioning. And
is that up to the judge, Mr. Reardon? Because in the Crowley case, the judge in that instance said, I'm going with essentially I want to hear what you have to say, Mr. or Ms. Defense Attorney. But is that the judge's call that we owe deference to?
I think the judge should consider all the evidence before him.
But his overall decision is something we defer to, correct?
Yes, there is the abuse of discretion standard, but I cite Crowley for the proposition that the judge should be considering what the defense attorney is saying about how his relationship is working. And in this particular case, we have evidence that the judge did not consider that. In particular, on the third day of trial, defense counsel said, he's not able to help me with his case. And the judge responded, I have no evidence of that, sir. You can't make that argument. You can't inject facts. I'm referring to this specifically as supporting that the judge was not considering this. Again, this is the third day of trial, 3 days of the defense attorney talking about how he was unable to work with the defendant.
Isn't the judge making observations of the relationship, though?
Yeah, and that's certainly appropriate, but I mentioned in the brief, he didn't know what, the judge referred to the defendant, taking notes and interacting with the defense counsel. But the point is that the judge doesn't know the substance of that, and going to the substance of what the defendant was writing down or what he was saying to defense counsel was telling the judge that it's gibberish. He wants to raise a defense about his thyroid medications, about whether or not it should be long-term or short-term.
You know, the challenge, I understand your argument. I think that the challenge is sort of a derivative of Justice Gaziano's question, is that the judge is right there making observations, sort of like when the judge is making observations during jury impalement of a jury. And those observations don't always make it onto the page in a way that actually defines what the judge is observing. And that's a challenge with a determination, factual determination, legal determination of competency by the judge.
It is, undoubtedly. But I come back to the judge should be considering what defense counsel is saying about how his relationship is working. And
This happened a few times during the trial, Mr. Reardon, these defense attorneys saying something about competency and his inability to communicate effectively with his client.
yes,
On those occasions, did the judge make an explicit finding about either, not in so many words, but credibility, or how did, on all those instances, the judge react to the defense attorney rather than characterize it? How did the judge react to the reports from defense counsel?
he doesn't say anything, there's nothing in the record about the judge saying, well, I don't, trust your judgment about how this related. There was no question of the attorney's credibility or his assessment or anything else like that. There's nothing on the record.
There's nowhere where the judge says, I know you're saying this, but he's been examined, all these times, and they say he's fine.
Well,
not fine, but competent, I should say.
Well, undoubtedly that did come out, that, that I understand what you're saying, but, I've had him examined by the clinician and they're finding him competent to stand trial. So, yes, that is there, but as far as the attorney's credibility and his representations, there was no finding that wasn't credible. The second issue presented, Your Honors, is the defendant's request for a modification of the Mutina instruction, which of course instructs the jury about the consequences of an NGI verdict. And defense counsel specifically cited to the Chappell case and requested that there be no references to the time periods that the defendant would be committed if he was found not guilty by reason of criminal responsibility. And in particular, the instruction that was given was the model instruction, which talked about how there would be an initial 6-month commitment.
But the model in Chappell.
Yes, and about how there would be a 6-month commitment followed by annual reviews thereafter. And defense counsel wanted that taken out and to say that he would be committed and would be periodically reviewed. I would suggest to you that this court's subsequent case in, I don't know how you say this, Adjui, it's a 2021 case. It is dicta, but the defendant in that case was requesting that the 6-month time period be omitted from the instruction, and the court seemed to agree with it in dicta that it shouldn't be there. So I would suggest to you that the defendant's request is appropriate, and it follows with the reasoning of the Chappell case that talks about how omitting references to time standards was more compatible with the nature of the NGI defense. If Your Honors have no other questions?
I think we're all set.
Thank you.
Thank you. Okay, Attorney Alford.
Good morning, Your Honors. Pamela Alford for the Commonwealth. The Commonwealth asked this court to affirm the defendant's convictions of first-degree murder and aggravated rape for the murder of Mary Beaton. Here, the judge was well within his discretion to make a finding of competency. And as to counsel's representations, these were not ignored at all. In fact, this was an interactive process. Starting on day one, the court clinician was there. First thing, counsel had the opportunity to both talk to her and cross-examine her. And so what I would say is the judge's findings are informed by the testimony of the clinician. Counsel had the opportunity to express his issues to her and had the opportunity to cross-examine her on these issues. So she could testify as to whether in her clinical evaluation the defendant understood the difference between a bench trial and a plea, and she explained the defendant knows what he wants to do and it could explain why he wanted to do it. In terms of malleability, there was a question, does the defendant just go along with what you said? And the clinician's testimony was, responsive to this. Nobody was ignoring counsel's.
The clinician's given an opinion as to what the clinician believes.
Yep, yes.
Would happen as the nature of all opinions. But here we have essentially evidence on the ground where the defense attorney says, there may be an opinion that he's capable of communicating with you. I'm telling you, he's not. Doesn't the judge have to address that?
He does, and I suggest he did, because the test is capacity. It's not, the test isn't whether there is a good working relationship. This was the defendant's fifth counsel. The judge had presided over the history, much of the history of this case, including the motion to suppress, including the prior withdrawal of counsel on the eve of trial, and he was entitled to infer that this was a matter of trial tactics.
Did the judge make a finding of malingering?
The judge made a finding as to the claim of auditory hallucinations that there was some doubt that prior clinicians, not the prior clinicians historically had raised some claim about whether the defendant's claims of auditory hallucinations were accurate, were valid. The clinicians at trial addressed the defendant's claims of what he then termed to be racing thoughts, and address, well, do they interfere with your thought process? And the defendant could explain that he could ignore them. So these were all issues that were fully in play before the judge. So it wasn't that defense counsel was being ignored or discredited. It was that defense counsel was making layperson claims, which were then addressed by the clinician on a clinical basis of whether they went to, in her opinion, a deficit in the rational ability to assist counsel, and then ultimately provided support for the judge's legal findings, which were based not only on the clinician's report, because, and keep in mind, she came twice. She came right at the beginning of trial, then trial impanelment after that started. The second day, there were claims on what were termed at the time to be impairment of the attorney-client relationship. I suggest to you a matter of trial tactics. And counsel raised that he thought that there were some irrational things that the defendant was saying. So at the end of the day,
So you use the term trial tactics to characterize what the defendant was doing. Was there a finding that this was trial tactics or antics?
do you say antics here?
Well, whatever, I get what you're saying is that, some people don't want to be on trial.
Well, I also...
So, and then I've seen it where defendants will act up because they don't want to be on trial, but was there explicit finding that this was a tactic?
I guess, Your Honor, I'm using tactic in a different sense. I suggest further on in the trial, there were debate defendant wanted to fire counsel because he wanted to present a parathyroid expert who they had noticed, who they had an expert report, and that counsel proffered for the court, yes, we have this expert, yes, that a defense based on parasite issues involving psychosis could be plausible, but that based on the evidence in medical records determining the defendant's calcium levels, that the Commonwealth's rebuttal expert, because the Commonwealth had a rebuttal expert, could make this defense a net loss. So that's a matter of trial tactics. Defendant wanted to testify, and that is something that this court said that is within the autonomy of the defendant to determine, not a matter of competency. And very notably, when the judge is trying to parse out some of these disagreements, and he asks the defendant if he had been explained the right to testify, the defendant gives an extremely coherent answer. And he says, yes, my counsel didn't tell me to law on it, but he said it's my right to do so, and he recommends that I don't. So it's clear that some of the disagreements, and so I'm not using the word tactics to say malingering as not want to be on trial. I'm using tactics as this is strategy, that realistic-based strategy, that there was a real probing about whether these were irrational claims and whether these are rational or whether these were disagreements between counsel. And that's why you had the clinician come both on day 1 and on day 3. And when So at the end of the second week of trial, when there appeared to be a physical event, the judge appropriately stopped trial, excused the jury, had what turned out to be a separate clinician come back, determined that this was likely a stress-related event after she spoke to him, that the defendant hadn't been sleeping well, that the racing thoughts had kept him up, and he was now having trouble focusing, adjourned for the weekend, at the defendant's request, sent him to Bridgewater on Section 18, looked at medical records that were unremarkable, the Commonwealth would suggest, on the following Monday before proceeding with trial. So it's not that counsel was ignored, it's that the judge could rely on the evidence from the clinician and from the previous history of the defendant being reviewed for competency at high-stress events and being found competent, and a history of disagreements with counsel that determined that the defendant could rationally assist counsel, and that while it might not have been what counsel wanted the defendant to say, it may not have been a particularly agreeable relationship, it was in fact a competent relationship within the defendant's control.
Ms. Alford, what can we look at in the record to point to the judge looking at the big picture and making factual findings and applying those facts to the law of competency, so that it's clear that the judge is adopting his view on competency and not just taking the views from the reports and the experts?
Yes, Your Honor. So I would say, going to, I'll get you a record site, Your Honor. So clearly, at the end of trial, the judge says there's no doubt that he's competent. But on day 8, at page 78, so this would be, I believe, this 3/11/2019 transcript, and a response to defense counsel's comment about the accretion of issues. Well, the court has wanted to go through this very carefully because there was a history for incompetency some period of time ago, but the issue has been explored multiple times. At this point, the court had engaged a clinician on day 1 of trial. The clinician reported there was no issue of competency explored. This juncture, the court does not need to consider an 18B based on the great volume of material it has. And then later on day 10, pages 236 to 239, after the defendant testifies, judge notes that defendant made the election to testify, responded readily to each question, no confusion or delay, fully understanding of questions, that he showed functionality through trial. He took significant notes during the autopsy, conferred with counsel, disagreement as to a tactical decision. The defendant took the stand even if counsel felt not most practical choice. It was the defendant's choice under law. And there is also, if I can find it, I know that the judge particularly talks, actually this is going back to day 8 at page 76. The judge says, I don't think I need to go into it in detail, but I've had the opportunity to go through Dr. Carroll's report from 2015. I've gone through Dr. Kelso's report from 2017. I've gone through a number of records, including Mr. Totino's motion to withdraw and the materials there. The court does not see any difference between what is occurring now and what's consistently been occurring all along, which is that Mr. Beatty has complained about voice which is characterized sometimes as negative thoughts. They have not seemed to intrude at all. In fact, Dr. Carroll raised significant questions about whether or not they are legitimate. And then it appears from everything the court's been able to read that there isn't any difference presented when the clinician spoke last week to him. It would not be productive, I think, to have the clinician return today. She had indicated that in her conversation to the clerk. So the judge is making these findings. He's considering everything he has before him, all the factors that Hill sets out as to statements the defendant makes, observations, expert testimony, psychiatric reports. The judge had presided during a prior withdrawal of counsel. he had a great history with this defendant, and he was engaging the defendant on these issues, and while he's not required to rely on the clinician's findings have not been challenged. The clinician's findings was that she took what counsel had to say into account, that she modified or molded some of her questions to see, in terms of malleability, make sure that she's not leading him. She was able to respond to counsel's layperson concerns from a clinical point of view, which provide the judge basis to so find the defendant was competent. As to the second issue, Your Honors, the Commonwealth asserts the defendant's misreading Chappelle. Chappelle was concerned with two factors. One, the 40-day observation period, and two, that there wasn't, after the initial 6 months period, there wasn't expressive enough language that the periods of commitments could last indefinitely. If you look at Chappelle's, the provisional instruction in Chappelle at the appendix, it talks about the 6 months that counsel now objects to, and this was then modified by this court's SJC model jury instructions incorporated there. So there's just simply no internal inconsistency. There's a difference between an observation period, which is done after trial for 40 days, and the first commitment period, which is done after a finding of reasonable doubt that the defendant meets the standards to be committed. Certainly the judge, in following this court's model jury instructions, which I suggest are entirely consistent with Chappelle, did not err in or abuse his discretion in so giving that jury instruction or overruling the defendant's objection. And if there are no further questions, the Commonwealth will rest on its brief.